Hi, my name's Zach, and the case that I will be doing is the National Labor Relations Board versus Murphy Oil USA Incorporated. So this case involved the petrochemical company Murphy Oil. They had an employee, Sheila Hobson, and when she got hired, she had agreed to a individual arbitration agreement, which means that if any legal issues arrive while she's employed there, that they will not go to court. They will just settle it themselves. And then in 2010, Hobson and a couple other employees filed suit in the United States District Court for the Northern District of Alabama. They were filing complaints under the Fair Labor Standards Act. Murphy Oil sought to the court to dismiss the case and compel arbitration under the employment contract, and the court agreed. Hobson then filed a complaint with the National Labor Relations Board, and they went over her case. What was very odd is that there was a similar case going on with the National Labor Relations Board and this construction firm. And what had happened was they took this case to the United States Court of Appeals for the Fifth Circuit, and in that case, the Fifth Circuit ruled against the board, stating that the FAA was not overridden by the NLRA. And despite what that court said about this past case, the National Labor Relations Board still decided to side with Sheila Hobson and her fellow employees and filed complaints against Murphy Oil Inc., which then Murphy Oil Inc. obviously challenged that decision, and they went back to the same court, the Fifth Circuit Court. What was kind of unique about this time is that the National Labor Relations Board attempted to seek an in-bank hearing, which means that they just talked to more judges about the case instead of just the one, which was denied, and they favored the company again, saying the FAA is not overridden by the NLRA. But then what was really interesting about this case is that was not the end of it. Back in 2017, it reached all the way up to the Supreme Court, and this wasn't a very unanimous decision. It actually was very close, but the Supreme Court favored a 5-4 decision that the NLRA did not override the FAA, and that under the Arbitration Act, agreements to arbitrate must be enforced, and the NLRA does not have to overrule the FAA. And then after that was decided, all complaints and everything was just dropped, dismissed, the whole shebang. Thank you.